Hello, everyone. Welcome to Court with Krissy and my little lion, Linda. Here are four court shorts you probably didn't catch. In the first one, it might get you into the holiday spirit, but I think the defendant might have already tapped into the holiday spirits. We hope you like it. Court with Krissy and Linda is now in session.
All right, Mr. Lynch, you're back with us now. We are now on the record with case number 25-2816 SM. This is a case alleging a count of trespass. Ms. Farrar-Wilbur, have you had an opportunity now to speak with Mr. Lynch regarding the charge, the possible sentence, and his rights?
Yes, yes, thank you. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Lentz waives a formal reading of both, pleads not guilty. He will represent himself at this time. However, he's not waiving his right to counsel, and he also requests that the bond is continued as set in this matter.
Thank you. Yes, Mr. Lynch, you have the right to have an attorney. If you wish to hire one, you may do so. If
The
you
last time was a disaster.
Okay, if
I
you
never got a
represent
chance to talk.
Okay, if you represent yourself, that's fine. And if you decide you do want to try another court-appointed attorney, please give us a call and we will guide you through the process. All right, this takes us to the review of the bond, and you say you'd like to have that continued.
Please.
Okay.
I am penniless right now. I was trying to get my tree gear
Okay,
together
Mr.
when I
Lentz,
was locked out.
we don't want to say anything about the facts of the case right now, okay?
Okay. I just
Thank you.
couldn't get my tools to work.
Okay, Mr. Lentz, let's not keep talking about the case,
Sorry.
okay?
Yeah.
You'll have your opportunity to
I'm
talk about
tired.
the case when we set you for the pretrial conference, sir. You can talk to the prosecutor at that time. In the meantime, do you have a physical address? Where are you staying?
I am homeless. The last night I was in Traverse City, I was doing a little stealth camping. I slept under the Christmas tree downtown.
Okay, that's fine. I understand. But don't tell us too much in case it happens that maybe you shouldn't be doing the sleeping where you think you're
Oh,
sleeping.
I don't care.
Okay, yeah, we do. So we don't want
Not
you
against the law.
we don't want you to have any more cases while you're on bond, okay?
Right, yeah.
All right. So I will note that you are homeless. Please be watching your email address, which I believe you told us. Whoops, wait a
In the
minute.
next couple days, it'll be back on. I'm getting my phone, I think, tomorrow or the next day, and then it'll be back on, and then I'm golden for a month.
Okay, so the phone number we have, right. All right, the
Correct.
court will be sending you notices to that email address since you, and also to the Frank Street address so that you know when your next hearing will be.
So I will get physical mail and email. So if I get the email, I don't need the physical mail so much.
As long as you get it, but make sure that you're getting information. You should
Right,
get it
yeah.
this week. All right, so, well, this week is Thanksgiving, so you might not get it till Monday because of the
Okay.
holidays. But if you do not receive notice, please call the court so we can resend it to you.
I will.
We will be continuing the bond as set on the 13th of November. We do note that you have no priors. And your pretrial conference is the next hearing for this. That is with you and the prosecutor in person at the courthouse in Suttons Bay.
Awesome.
Talking with the prosecutor. That is December 17th at 9 o'clock in the morning.
What?
December 17th at 9 o'clock in the morning. You need to plan to be here at the courthouse. We'll be sending that notice to that email address for you.
I like to write it down anyways.
Certainly, take your time.
Yeah, when I went to court years ago and lost my children for 5 years, I told my attorney that the cop in the report
Okay,
said the
sure.
exact
All right.
opposite.
That
Sorry,
was a
I'm
different
sorry.
court. Yeah, that was a different court altogether. This is district court.
He's in real trouble.
Okay, well, you were in family court, so two different things here right now. Okay, so 12/17 at 9 o'clock, we'll see you here at the courthouse.
12/17, 9 a.m.
Yes, and if you find a place that you're going to be staying, please let the court know so that we can note that in your file. Okay, sir?
Right. And I won't tell you if I'm going to sleep out behind the
No,
building
don't
that
tell us
night.
where you're
I
going to be.
won't tell you
No, you
that.
don't need to tell us that part.
I'll be the one dressed like an Eskimo.
Okay, yeah, you and some others. All right, sir, will you take care?
Thank you very much.
Bye-bye now.
Bye.
All right, next is case 250945, case 250919, case 250655, and case 250331. The people of the state of Michigan versus Eva. And appearances for the record.
Thank you, Your Honor, and good morning. Gabrielle Lethal, Assistant Prosecutor for the People.
Good morning, Your Honor. David M. Boer for Delhi Charter Council. May it please the court, David Capelli, Assistant Public Defender, appearing on behalf of Ms. Eva Mena, who is standing to my left. This is the date and time set for a competency review, Your Honor. I am prepared to stipulate to the contents of that report. I would note for the record that I disagree with its findings and would ask that inform the court that we intend to seek an independent evaluation of Ms.
So are they saying that she is competent?
That's correct.
And you think that there might still be some issues?
I do, Your Honor.
Okay, well, you certainly can see if you can get a second opinion, but we probably should get the train moving with regard to what the Center for Forensic Psychiatry has decided. So, first matter is case 250331. This is Delhi Township. It's on a disorderly. Mr. Rapport, are you stipulating that the defendant is in fact competent?
Your Honor, one more time, I didn't.
Are you stipulating that she is in fact competent?
I'll stipulate to the contents of the report as well, but I do not object to them seeking another.
No, we don't care about that. He can do that. But in terms of us being able to go ahead and schedule things, we can do that too. Right?
Okay.
All right, so I'll sign this one. Is she receiving any medication to help her with her competency?
Not that I'm aware of, Your Honor.
Yes,
What are you receiving?
I can't remember the medication, name of the medication, but I've been taking it fine. But the month that they lined this up, and I didn't know, they did not have my medication for the whole month, and I got sick. I ended up having a seizure on my monkey's lap, and yeah, didn't get no medication at all.
So the defendant is receiving medication and she needs to continue to receive medication that shall be administered during her time with us. So we're going to try and schedule these all to be heard on the same day, or what are we going to do?
I believe where we're at, Your Honor, is that we had a number of bond violations that were being held in abeyance until we received this report.
Okay.
So probably the next step would be to schedule a hearing for those.
Okay.
Yeah, there is one felony.
Okay. So in this file, she is real competent and will schedule it for hearing. You have a date in mind for this?
We could set those all for December 8th. She has
December 8th at what time?
9 o'clock.
At 9?
Yes, because Mr. Report is here in the morning. Only.
Here at 9. Usually.
Well, it's a pre-trial.
Okay.
And then you can do the bond violation after that, Your Honor. So
Okay.
sorry, I
You
know
threw
what
me.
you're saying. Yeah.
You permit.
And then the felony we could schedule for the 9th.
Which case is the felony?
I have it here. That is one that was not sent to the forensic center. We just held it.
Okay. Is that all of those are her files too?
Yes, Your Honor.
You know what? I'm sitting in jail. No, because I'm perfectly fine. My rights were not read to me every time. No, because they were not.
Excuse me. I'm actually having a conversation with my assistant.
Yes,
You're not supposed to be listening to my conversation.
I know, but it happens to me all the time. I was asked to.
I
Why?
said you're not supposed to listen to my conversation with my assistant.
Yes.
8:30 for the pre-trial?
For the pre-exam conference. Of the,
9:30 for the.
on the 16th, yes.
All right, so on this matter, this is case 25-1741. This is the felony. That matter will be heard on December 9th at 8:30. And the exam.
I'm already pleading guilty. No, I'm pleading guilty because I'm tired.
So you go ahead and just take her back to the back. Thank you. All right, so bond is continued on this one.
Your ticket bears the caption 25R06278. You were ticketed back on the 5th of October at about 9:10 in the evening. The officer cited you for impeding traffic instead of for running a red light. Running the red light would be 3 points, impeding has no points. Are you here to accept the break that he gave you on the street or to reject it?
I wanted to reject it.
You have that right, but if we proceed to trial and the hearing discloses that you were in fact not impeding, but were running a red light, that you ran a light, the ticket can be amended to the red light.
I don't want that either. But the ticket is kind of high as well. I really don't feel like I ran a red light. Like I was turning, making a right turn on Main onto Rochester Road.
This isn't the time for discussion of what happened. This is the time that we need to ascertain if you want to accept responsibility for impeding or if you want to deny, and you could be found possibly. I wasn't there. I don't know what happened. You do. And if you want the hearing, fine. If you don't, then you can accept responsibility for impeding.
I just accept the responsibility. That's enough for that.
For impeding.
Yep.
Yep. Okay.
This is stupid.
You want a hearing?
No, I don't. Because I don't have time for a hearing. So I just take the impeding traffic.
Officer Francis, do you want to amend the ticket now?
Yes, Your Honor. I'd like to amend to the red light violation for disregarding the red.
We'll be hearing on the red light, Ms. Jackson. Raise your right hand, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
The officer will testify first.
Your Honor, on October 5th, approximately 9:11 p.m., I was in the area of Main and Catalpa when I observed a red Jeep Compass with license plate 8 Nora Zebra 84 disregard a solid red signal while traveling northbound in Main at Catalpa. Driven by Miss Jackson, who is present here.
Ms. Jackson, it's your turn.
From my knowledge, I was coming down Main, about to make a right turn onto Rochester. And the way it's set up is either you can go straight or go to further to the right.
Ma'am, you can't make a right turn from southbound Main.
I was going north, like, well,
Northbound
however,
Main.
the way it is, the way it's set up, Rochester, it splits up. So it can either go straight to Rochester this way or to the right. I don't know what the other side is, but I was going straight towards Rochester.
Okay. The allegation is that you ran the light at Catalpa.
I didn't run a red light. And if that was the case, like I said, I don't remember running a red light. I don't believe I ran a red light whatsoever. If I felt that I read the red light, then I wouldn't even went through all this to get a court date or none of this. If I felt like I did that.
We're not talking about feelings, ma'am. We're talking about facts.
I know facts. I don't believe I ran a red light. And I don't, granted,
What
he
color
was
do you
very
think the light
nice.
was when you went through?
It was yellow.
What does yellow mean? What does solid yellow mean?
Yield or
Yield?
stop.
Yeah, means stop.
Okay.
I think you ran the light. I'm finding you responsible for running the light.
Okay. No, I got 3 points. Mhm.
If what the fine is on that. Fine on that is 150. You were right about the 3 points. Competing would have been 175, so you saved $25 on that. You can pay it online or by mail or at the courthouse counter. Thank you.
Mr. Sadek, can you hear and see me okay?
Yes, sir.
Were you present in court when your rights were read to you?
Yes, sir.
Do you understand your rights?
Yes, sir.
One of the important rights you have is the right to be represented by counsel at every stage of the proceedings, including this one. You have the right to hire a lawyer. You have the right to apply for a public defender. You have the right to represent yourself. How would you like to proceed, sir?
At this time, I'd like to represent myself.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to waive your right to counsel?
No, sir.
And do you understand, sir, that at any time you can change your mind and either hire a lawyer or apply for a public defender if your case is still pending?
Yes, sir.
Court will find a knowing and voluntary waiver of the right to counsel. Mr. Sadek, have you received a copy of the charging document in this case?
Yes, sir, I have.
You have the right to have that document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing it?
Yes, sir.
The state alleges that on or about November 21, 2025 in Barnes County, North Dakota, that you committed 3 offenses. They are all the same offenses with respect to different victims. That's why there are 3 counts. In count 1, the state alleges that you committed the offense of terrorizing by, with the intent to place another person in fear for that person or another's safety, or in reckless disregard of causing such terror, that you threatened to commit a crime of violence or an act dangerous to the life of Alex Sadek. Or is it Sadek? Sadek?
Sadek, that's my dad, and that is not true, the allegation.
I understand, and I'm not asking you for commentary on what you think about the charges right now. All I'm asking is, do you understand the nature of that charge?
Yes, sir, I do.
All right. Count 2, it's the same crime. The state alleges on or about that same date in Barnes County that you committed the act of terrorizing by threatening to commit a crime of violence or an act dangerous to the life of Kathy Sadek. Do you understand the nature of that charge?
I do understand the nature of it.
All right. Count 3, the state alleges on or about that same date in Barnes County, you committed the offense of terrorizing with respect to Jaden Opatz by threatening to commit a crime of violence or an act dangerous to his life. Do you understand the nature of that charge?
I do understand the nature, yes, sir.
All right. All 3 charges are Class C felonies. So all 3 charges have the same maximum and minimum possible penalties. What I'm going to say from this point on applies to all 3 charges, sir. All 3 charges are Class C felonies. The maximum possible penalty is 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any minimum mandatory penalties for any of the offenses except for a requirement to submit fingerprints and a DNA sample for inclusion in law enforcement's databases. If you're convicted of any Class C felony, the court fees associated with a Class C felony total $525. If your alleged conduct caused any financial harm or injury to another person, the court can order restitution. If you are not a United States citizen, a conviction of any of these charges can carry with it significant adverse immigration consequences. A conviction may also carry with it significant collateral consequences for which the court is not required to explain. Do you understand the nature of the charges, the maximum and minimum possible penalties as I've read them to you, sir?
Yes, sir.
Because these charges involve felonies, I am not going to take a plea of either guilty or not guilty today. That decision will be made at a later date, and I will get that later date for you in just a moment. The only other issue that we need to address right now is bail. Mr. Sadek, you were arrested over the weekend, and I had previously determined probable cause existed to support the 3 charges, and I set your bail initially over the weekend at, I believe, $7,500 cash or 15,000 corporate surety. I'm going to hear from the prosecutor as to what he thinks I should set your bail at. And then I'll hear from you, sir, and then I'll revisit that bail decision that I made over the weekend. Do you understand that, sir?
Yes, sir, I do.
All right. Mr. Jackson, your thoughts on bail?
Your Honor, I believe, given the nature of the offenses, what the court set at bail at over the weekend is appropriate. I do also want to draw the court's attention to the declaration of probable cause, citing that the defendant was acting manic or was on meth. Your Honor, today I also received an unsolicited phone call from one of the defendant's family members indicating to me that his mental health may be in question. Over the last six months, his behavior has changed significantly. He does have a history of drug use, but he had been sober for approximately 12 years, this individual believed. Further, they disclosed to me that he has had 2 significant head injuries in his lifetime and that a mental health issue runs within their family. I just wanted the court to be aware of that should they deem anything else should be appropriate. I do believe that as well as the declaration, which included that language, they're corroborative of each other insofar as the defendant's mental health may be in question. Thank you.
Mr. Sadek, you've heard what the prosecutor has suggested I do with your bail. We'll take that question up first, and then we'll address the next part of it. So, sir, you have the right to tell me anything you want with respect to bail. Because you are not represented by an attorney, I'm going to warn you that anything that you say can and will be used against you. These are recorded proceedings, so I don't want you to make factual statements about the alleged offenses. I don't want you to make any statement that can be used to harm your case, sir. But it's your opportunity to tell me what you think I should do with bail and why. You don't have to say anything. You have the opportunity to say something if you want, but you don't have to say anything. And if you do say something, sir, just understand that whatever you say can be used against you. So I give you that warning before I give you an opportunity to speak. Is there anything you want to tell me about bail?
Yes, sir. So I am a general contractor along with farmer rancher. I've got a lot of things going on, and I have got a sewer main line open at the moment that I would like to go get to, and I don't have any cash. I mean, I'm not doing well as far as financially goes. The last 2 months of me starting contracting, I had hooked up with a couple of guys that had taken advantage of me, and I just figured I'd go to the next one and make it back up and not figure too much on it. But so yeah, I'm not doing very well as far as that. If I could get like a reduced, but I don't even know, I don't have the money to bail myself out if Tammy Drake or my grandma or somebody doesn't post it. I don't even have the cash on me right now. I need to go finish that job and yeah. So and as far as my that night, I don't know if you're aware, but my kids were taken from me. I have a court order that it was supposed to be my weekend at 3 o'clock. And I went to go pick them up at school, and my kids' mom had already got them and took off with them and said that I wasn't going to get to see them. So I guess that was kind of the start of all of my, like I was sober and I told them that I'd take a test. And I'd still take a test any day, as far as, anything, whatever. So, I am here. I have a farm north of town, about 10 miles. I'm a farmer and, I'm getting into ranching and the general contracting. And I would really appreciate it, Your Honor, if you could give me some kind of PR bond. I understand wherever you're at and, what you choose is what it is. But Your Honor, I plead mercy with you that I can go back to get my life on track, because I have to come up with $40,000, whether I sell my cows, finish this job and some other jobs by December 1st, or I have the potential of losing my farm. And I have animals out there that need to be fed.
Anything else, sir?
And I believe that should be all, Your Honor.
All right. Well, the court's considered the constitutional provisions concerning bail, including Article 1, Section 11 of the North Dakota State Constitution that deals with bail. The courts consider Rule 46A, which includes a presumption of release on personal recognizance unless the court has sufficient evidence before it to rebut that presumption. The defendant would appear on an unsecured appearance bond. Here, the court believes that has been established. The court sets bail. For now, I'm going to leave bail as it was set previously over the weekend. I believe that's appropriate and reasonable under the circumstances in light of the nature of the offenses. I am going to leave in place that bail for now. That being said, sir, if you remain in custody for longer than 48 hours following today's hearing, you can request a bail review. A bail review does not mean a bail reduction. It means that a magistrate will review your bail. Bail can go up, it can go down, it can stay the same, but you do have the right to request a bail review if you stay in custody for longer than 48 hours. The court finds that previous conditions are appropriate. I will note, sir, that your next court date is December 30, 2025 at 1 p.m. in the Barnes County Courthouse. Do you understand when you next need to be in court, sir?
Yes, sir. And if I could mention one other thing, I know I'm not supposed to say things to incriminate or whatever, but just on kind of what had happened here, if you're interested, of what was said that night and why.
Well, that's for another day, sir. I certainly appreciate you wanting to explain, but I'm at this point not going to. It's just not the appropriate time to do that, sir. So you're going to have an opportunity to explain what happened if you want, but that's not for right now.
Okay.
So I've made my bail decision. I just want you to understand that it's not that I'm trying to tell you that I won't listen to you. It's just that now is not the appropriate time.
Okay.
So hold those thoughts for now, okay? And in terms of the mental health issue at this time, the court's not going to take any particular action. If Mr. Jackson believes fitness to proceed is an issue, he can file the appropriate motion and we will take it up. But for now, based on what I have heard, I'm not going to take any unilateral action. The court's observations is that Mr. Sadek appears to be oriented to time and place and has responded appropriately and in context to the questions the court has posed. Mr. Sadek appears to understand what is going on. He's made comments that he believes that he was sober, and the court takes those at face value. But again, if Mr. Jackson is concerned about Mr. Sadek's fitness to proceed, he can file the appropriate motion under North Dakota Century Code Chapter 12.104. Anything else, Mr. Jackson?
No, Your Honor, thank you.
Anything else, Mr. Sadek?
I'm just wondering, so the 1750, is it 10% of that, or is it the full 1750 to get out?
It's 7,500. It's
Gosh.
the full 7,500
Oh,
or a $15,000 corporate surety bond, which means that you can get a bail bondsman, and the bail bondsman will charge you much less than $15,000, but probably would still charge you $1,500.
$7,000.
Those are options that you can explore with the bond. That's what I said, bail at.
So that's the full 7,000. That's not 10% of any of that.
No.
Oh
It's
my God.
one or the other at your option. It's either $7,500 cash or, in the alternative, $15,000 corporate surety through a bail bondsman.
I don't know what that
Plus
is.
conditions. Yeah, so the jail can help you with that. With
Uh,
that, we are adjourned.
I'll bring you back.